Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. I hope everybody is doing well. It is beautiful here in Florida, and I hope it is beautiful weather where you are too. And so I know it's been a minute since I brought you guys a video. I have had a lot going on. Mainly, I had surgery on my mouth and I have stitches. Well, first I had like these bandages, these oral bandages all over my mouth. So the bandages have fallen out, but the stitches are still in. So if it sounds like I'm slurring my words, it's because of the surgery I had on my mouth, and I don't get the stitches out until Friday. But anyway, I am here to talk about Mr. Michael Williams. And for those of you who have been following the R. Kelly case, you know that Michael Williams is the cousin of Cash Jones, who set a car on fire at the Clary said it was their house. I believe it was a rental property, and the car did not belong to Ariel, although he was charged with witness intimidation and setting the car on fire to intimidate Ariel from testifying. We know that the car was a rental vehicle and it was rented by Angelo Clary. So in any event, the government tried to get Michael Williams to enter into a plea agreement, but he was not having it. They continue to claim that he was working in coordination with R. Kelly and that he did this witness intimidation, on behalf of R. Kelly. But I don't think that Michael Williams actually admitted to doing that. I'll have to go through some of the other documents to see if we have the document where he actually testified in court and took accountability for setting the car on fire, and try to find out exactly what he said. But according to the media, they're still sticking with the story that he was a R. Kelly associate who did this to keep Ariel from testifying, when we know that no mention of Michael Williams came up during the trial against R. Kelly, which took place back in September. So anyway, I'm going to go ahead and read this article by Complex, and then I am going to read a court document that was filed yesterday by the prosecution, who wanted Michael Williams to get the maximum sentence possible. And we know the reason that they're doing that is because he wouldn't cop to working with R. Kelly or being told by R. Kelly to do this. So we already know that that's why they're pissed off, and they want this man to spend as much time in jail as possible. So according to Complex, it says an R. Kelly associate has been sentenced to 96 months for witness intimidation in connection to the singer's sex crime and racketeering case. And I am going to reiterate that R. Kelly did not know Michael Williams. Michael Williams was not an associate of R. Kelly's, and R. Kelly did not instruct Michael Williams to set this car on fire. So the United States Attorney for the Eastern District of New York announced the sentencing Wednesday, about 7 months after 38-year-old Michael Williams pleaded guilty to an arson charge. The Georgia resident admitted to authorities he had traveled to the home of one of Kelly's accusers and set fire to a vehicle that was parked outside her Florida residence. Prosecutors say Williams' deliberate actions were intended to scare the woman and prevent her from cooperating in Kelly's federal trial. Williams, a relative of Kelly's former publicist, and let's stick a pin here because Cash Jones did not work for R. Kelly. She was not R. Kelly's publicist, and I don't know why the media continues to run with these false narratives. So we need to go on Complex's social media pages where they've shared this article and let them know that R. Kelly did not know Michael Williams and Cash Jones did not work for R. Kelly, and that neither one of them testified in R. Kelly's trial. Okay, so we know that this is all a fabrication by the prosecution. So it goes on to say, reportedly arrived at the accuser's house on June 11, 2020, and poured gasoline over an SUV that was leased by the victim's father. Prosecutors say the witness, identified as Jane Doe in court documents, was inside the home at the time of the incident, along with 3 other adults and 2 children. The accuser's mother reportedly called 911 after seeing the flames outside. And then as I scroll down past all these advertisements and pictures, we also want to point out that Cash Jones allegedly was having an affair of some sort with Angelo Clary, and that this arson was actually targeting Angelo Clary and not Ariel. So it says, according to the Department of Justice, investigators also found traces of an accelerant outside the witness's home. They also said Williams had conducted internet searches about the detonation properties of fertilizer and diesel fuel, witness intimidation and witness tampering, and countries that do not have an extradition agreements with the United States. Like, where was his broke ass going? Please help us understand. And so then the article wraps up and says, Assistant U.S. Attorney Maria Cruz Melendez read the following statement from the victim during the sentencing hearing. Let's see. Williams is one of 3 men. Okay, they don't have the letter here. Williams is one of 3 men who have been accused of harassing, intimidating, and or threatening some of Kelly's accusers. Back in September, the singer was found guilty of 8 counts of sex trafficking and 1 of racketeering. The artist is now facing between 10 years to life in prison. The sentencing is expected to take place in May of 2022. So let's see if we can find this letter that Ariel supposedly wrote, because I'm sure she didn't read it. She didn't write it. She probably the prosecutors probably wrote it for her. Anyway, I can't find the letter, but we're going to read this information that was filed last week by the prosecution, where they are pissed off and they want this man to get as much time as possible. And so it says, Dear Judge Donnelly, the government respectfully submits this letter in advance of the sentencing of defendant Michael Williams. Williams, or the defendant, is how he'll be referred to throughout this document. Scheduled for November 17, 2021 at 12 o'clock p.m. And for those of you who follow my videos, you know my computer has a habit of skipping around. So I got to get back to where I was reading. And then just use the down button. Okay, it says, as set forth below, the defendant's applicable guidelines range of imprisonment of 60 to 63 months imprisonment. In his sentencing memorandum filed on November 8, 2020, the defendant requests that the court impose the statutory minimum sentence of 60 months imprisonment. For the reasons set forth below, particularly given the serious nature of the conduct of conviction and the context in which it was committed, the government should impose a significant term of imprisonment above the applicable guidelines range. And then to show you guys just how pissed off they were that they couldn't get Michael Williams to say what they wanted him to say, he was sentenced to 96 months. So that is 33 months or close to 3 years above what was recommended, the recommended guidelines. So they give the background, and it says the offense conduct. In the early morning hours on June 11, 2020, the defendant maliciously set fire to a vehicle, destroying it in order to intimidate and threaten a victim witness in a case pending before the court. Hereinafter Jane Doe and her family. As the court is aware, on June 20th, 2019, a grand jury in the Eastern District of New York returned an indictment charging Robert Sylvester Kelly with racketeering involving predicate racketeering acts as to 5 different women and 4 Mann Act violations, and then they give the case number. On subsequent dates, the grand jury returned superseding indictments, including on March 12, 2020, when the grand jury returned a 3rd superseding indictment. Let me go back up here because, okay, they did say 2019. Okay, jury returned a 3rd superseding indictment against Kelly. Among the charges against Kelly in the 3rd superseding indictment were offenses that carried a 10-year mandatory minimum sentence based on Kelly's sexual relationship with Jane Doe. Knowledgeable of the investigation and prosecution against Kelly, as well as Jane Doe's cooperation with the government, the defendant, a relative of an individual who briefly acted as Kelly's publicist, engaged in the conduct of conviction to intimidate and threaten Jane Doe with the intent to prevent her from cooperating with the government's investigation and, as a result, significantly interfering with the case against Kelly. So can somebody tell me why Cash Jones has not been arrested? So they claim that she was a part of this scheme. Then in the hearing, she was a part of some scheme at the Applebee's involving Faith Rogers, and then we also know she was involved somehow with Don Russell in all of this witness intimidation and trying to stop Surviving R. Kelly from going forward. So why has Cash Jones not been arrested? Why is she not being charged with anything? Like questions that make you go, like what really was her role in all of this? So it goes on to say it specifically, on the evening of June 10, 2020, through the early hours of June 11, 2020, the defendant and his stepson traveled in the defendant's GMC Yukon from the vicinity of his residence in Valdosta, Georgia, to a home in the area of Florida where Jane Doe was living at the time. Now, this is the first time I'm hearing that the stepson was in the vehicle with him. Why has the stepson not been named? And this is the first time we're hearing about this. Surveillance video from a gas station at a Pilot Travel Center in Valdosta, Georgia, shows that the defendant and his stepson filled the car's fuel tank, as well as 2 red containers with gasoline that they placed in the trunk of his car before making the lengthy drive to Florida. Now, I would have been terrified that the car was going to blow up. I go buy gas at the gas station near my house and be terrified driving back home. Here they are, then drove from Valdosta to Central Florida, which is like a 5-hour drive with 2 things of gasoline in the trunk of the car. So it goes on to say, after arriving at Jane Doe's house at approximately 2:50 a.m. on June 11, 2020, the defendant and his stepson, using the gasoline that they had purchased en route to Jane Doe's home as an accelerant, set fire to a black SUV, referred to as the vehicle, parked outside of the home where Jane Doe and her family were staying. As seen on surveillance footage from the vicinity of the crime scene, after setting fire to the car at approximately 2:53 a.m., the defendant then fled the scene at a high rate of speed. Subsequently, the defendant drove back to Valdosta, Georgia. What happened to the stepson? Why wasn't he charged with arson? Why is this the first time we're hearing about the stepson, y'all? So anyway, you guys know that they have notes at the bottom of some of the pages. So let's go ahead and read this note before we continue on. It says, individual one, who is Cash Jones, was herself involved in a scheme with Kelly's associate Donnell Russell to intimidate another of Kelly's victims to stop speaking publicly about Kelly and withdraw a civil lawsuit against Kelly. As part of this intimidation scheme, let's just call her Cash Jones, and actually it's not even Cash, it's Cashmere Jones. I believe it's her real name. Individual one confronted one of Kelly's victims, who was subsequently referred to as Jane Doe number 6, and we know that this is Faith Rogers, while she was in New York for the premiere of the Lifetime documentary Surviving R. Kelly. As Jane Doe number 6, Faith Rogers, testified at the Kelly trial during a conversation which occurred at an Applebee's restaurant, Cash Jones, who was with a man Cash Jones referred to as her security guard, among other things, told her she worked for Kelly and showed Faith Rogers new photos of herself and advised her that Kelly planned on releasing these photographs if Faith Rogers and the other accusers moved forward with the documentary. Further, as Faith Rogers and her mother each testified in Kelly, referring to the trial, the male stood in a corner of the restaurant and each saw that he had a gun under his jacket. Notably, during an interview with law enforcement, Cash Jones advised that she was with Williams at the Applebee's, where this conversation occurred. In addition, flight records show that Williams and Cash Jones flew together from Fort Lauderdale, Florida to LaGuardia Airport in Queens, New York earlier that day, which was December 4th, 2018, on Spirit Airlines, and both left New York the following day, December 5th, 2018. Okay, let's see. So that was the end of the note. And if you guys want to hear Faith Rogers and her mother's testimony from the hearing, I'll drop those videos, the links to those videos above, and you can go back and listen to the transcripts from their testimony. So let's go ahead and pick back up with the letter. So it says, at the time the defendant committed the arson, 4 adults, including Ariel and 2 children, were inside the home. After discovering that the vehicle was on fire, the family made multiple calls to 911. One of the adults reported to law enforcement in part and in substance that upon hearing an explosion, she ran outside of the house and saw an individual fleeing from the scene of the fire, whose arm appeared to be lit on fire. During review of the crime scene, fire investigators determined that an accelerant was used to set fire to the vehicle. At the scene, investigators discovered a red container consistent with those seen in the Pilot Travel Center surveillance footage, as well as a black hooded sweatshirt with damage to one of the sleeves consistent with a sweatshirt worn by one of the 2 individuals, and then they have in parentheses the defendant and his stepson, captured in the Pilot Travel Center surveillance footage. The vehicle, which was rented in Florida by Ariel Clary's father from Enterprise Rent-A-Car, sustained substantial damage as the result of the arson. Significantly, fire investigators also determined that accelerant was present along some or all of the outside perimeter of the home. As discussed in more detail below, the government's investigation revealed that, among other things, the defendant used his Google account to conduct research in preparation for and to avoid detection of his criminal activity by A, looking up Ariel's residence multiple times online, both before and shortly after he committed the charged arson, B, viewing multiple YouTube videos related to Ariel, as well as visiting several websites about women who had made allegations against Kelly and news about Kelly's case. C. Searching websites that contain the statutory language for several of the same charges filed against Kelly, including transportation of minors, coercion and enticement, and racketeering. D. Researching whether one could travel to Florida without a license plate. E. Looking up the extradition laws of various countries. F. Researching the laws and penalties related to federal witness intimidation and witness tampering statutes. G. Searching for where he could buy a custom machine gun. And H. Gathering information about how fertilizer and diesel fuel bombs work. Now, that's what they say that the Google search revealed, but Michael Williams, I've never met him before, but he just doesn't strike me as somebody being that smart to have been looking up all these different things. So did Cash Jones set her cousin up? Was Cash the one looking up all this stuff? Because I'm starting to think that Cash Jones might be working with the feds, y'all, because she seemed to have set up a whole bunch of people, but she's still walking around freely like she don't have a care in the world, and the government doesn't seem to be too concerned about it. So then B, it says the defendant's arrest and guilty plea. On August 11, 2020, the defendant was arrested on a complaint at a hotel in Pompano Beach, Florida, located in the Southern District of Florida. At the time of his arrest, a consent search of the hotel room where the defendant was staying revealed a 9mm high-point handgun with an obliterated serial number that contained 9 rounds of ammunition inside. The handgun contained 1 round in the chamber and the remaining 8 rounds in the magazine. The gun was in a black holster located in a black Armor All bag. Let's go back up here, August 11th. So who filed the complaint at the hotel, and what was the complaint? Did Cash call the police and tell them that her cousin was in that hotel room with a gun? Because what just made the police show up at the hotel? Who filed the complaint? So anyway, on September 23rd, 2020, a grand jury sitting in the Eastern District of New York charged the defendant in a 2-count indictment with witness tampering in violation of United States Code 18-1512B1, Count 1, and arson in violation of United States Code 18-844I, Count 2 of the indictment. On April 19, 2020, the defendant pleaded guilty before this court to Count 2 of the indictment. So Part 2. Sentencing guidelines range in applicable statutory terms of imprisonment. As set forth in the Pre-Sentence Investigation Report, referred to as PSR, the Probation Department has determined that the defendant has an adjusted offense level of 26 based on the following. So the base offense level is 24, and then he got 2 points for offense committed to conceal another offense, for a total of 26 points. So PSR 22 through 27, given a total adjustment offense level of 23 due to a 3-point reduction for early acceptance of responsibility and a criminal history category of 2. And then the PSR 109, probation has calculated the defendant's advisory guidelines imprisonment range to be 51 to 63. However, and they're referring to months. However, given his conviction on Count 2 of the indictment, the defendant faces a statutory minimum sentence of 60 months imprisonment, resulting in an applicable guidelines range of 60 to 63 months imprisonment. So then they have a note here, a very long note. It says the plea agreement executed by the parties Sorry, somebody was tapping on my window there. It says the parties in this case estimates that the applicable guidelines range is 60 to 71 months imprisonment based on the government's calculation that the defendant's criminal history places him in criminal history category 3. This calculation was premised on the separate treatment of sentences imposed on the defendant in 2004 and 2006. Now, they're going to supersede what the probation people is recommending the sentences, and I hope you guys are paying attention, because I trust and believe when Robert Sylvester Kelly is getting ready to be sentenced, although he has no prior criminal history, although these heifers up there lying through their teeth on that witness stand, they're still going to try and come up with all this other stuff to try and increase whatever sentence they want him to have. And we know that Judge Donnelly is going to go along with it, just as she did in this case, because she is the sentencing judge here. So it goes on to say, specifically in 2004 and 2006, the defendant's probation was revoked and he consequently received amended sentences of 11 years confinement and 5 years confinement respectively, related to prior convictions for burglary and grand theft in Florida. Depending on the circumstances under which these guidelines were imposed, each amended sentence could be counted separately under the guidelines, which is what is reflected in the plea agreement. As set forth in the PSR, as it is unclear from the records when the defendant committed the conduct noted above, it is unclear if there was an intervening arrest. The two cases are being treated as a single sentence. Further, probation has advised that they have not yet received the requested records, which could provide additional information relevant to these amended sentences. Absent the additional requested information or sufficient information of the relevant facts regarding these convictions from the defendant regarding the 2004 and 2006 amended sentences prior to the defendant's sentencing in this case, go down. The government does not object to probation's calculation of the defendant's criminal history category. Okay, so let's continue on with their discussion. So let's see. So discussion. It is well settled law that a sentencing court should consider all of the 3553A factors to determine whether they support the sentence requested by a party. In so doing, it may not presume that the guidelines range is reasonable. It must make an individualized assessment based on the facts presented. And then they use the case Gall versus United States from 2007. It says Title 18 United States Code Section 3553 provides in part that in imposing sentence, the court shall consider the nature of the circumstances of the offense and the history and characteristics of the defendant, the need for the sentence imposed, to reflect the seriousness of the offense, to promote respect for the law, and to provide just punishment for the offense. B, to afford adequate deterrence to criminal conduct. And C, to protect the public from further crimes of the defendant. As set forth in further detail below, the Section 3553A factors plainly warrant a significant above-guideline sentence. A, nature and circumstances of the offense. Here, the nature and circumstances of the defendant's conduct are nothing short of egregious. First, notwithstanding the defendant's description of his actions as a grave mistake, the cold and calculated manner in which the defendant carried out the arson cannot be ignored. The defendant's conduct was not done on a whim or under stress. Rather, it was cold, calculated, and premeditated. As discussed above, a search of the defendant's Google accounts revealed that prior to committing the arson, the defendant clearly researched Jane Doe, Ariel Clary, For example, on April 10, 2020, the defendant searched the address of the home where Ariel was living on multiple occasions. And in May 2020, the defendant viewed multiple YouTube videos about Ariel. The defendant also considered ways in which he could avoid detection after committing this crime by, for example, removing or otherwise concealing his license plate using one of his Google accounts to search in April 13, 2020, can you drive in Florida without a tag as long as you have insurance on your car? Or by potentially fleeing the country, using another Google account to search for countries that don't have extradition from the United States on June 7, 2020 and June 9, 2020. Prior to committing the crime of conviction, the defendant even conducted an online search for where can I buy buy a .50 custom machine gun. Now, y'all notice they said here that he was using another Google account to search for some of this stuff, which still leads me back to Cash Jones. Did she set this boy up? I think she did. What do y'all think? Y'all let me know in the comments if y'all think Cash Jones set her cousin up on behalf of the government. Okay, so it says, at every stage of this planning, the defendant had an opportunity to abandon his intentions. Notwithstanding, he drove approximately 225 miles over several hours between Valdosta, Georgia, and Ariel Clary's home in Florida to carry out this crime, stopping on the way to purchase 2 containers of gasoline, which he used to carry out the arson. And as reflected in Williams' receipts for that evening, snacks including Lifesavers, chocolate chip cookies, and 4 cans of Red Bull for the long journey. Further, the callous nature of the defendant's conduct cannot be overstated. The defendant not only drove to Ariel Clary's home in the middle of the night and set fire to the vehicle, but most disconcerting, the fire investigators also discovered accelerant surrounding the perimeter of the house. Now, y'all know Angelo poured that out there. It probably had nothing to do with that car being set on fire, but you know, the Clarys are a very dramatic family. So I wouldn't be surprised if they grabbed the container that was left there and said, oh, let's go pour it around the house and make it seem like he was going to burn the house down. Anyway, let's see. If the defendant has succeeded, in setting fire to the house, it would have no doubt resulted in additional destruction of property, but more significantly could have led to tragic loss of life. His actions reflect that at best, he gave no regard to the safety of Ariel Clary, her family, and that of the emergency personnel who responded to the scene, and would have had to tackle a house fire if the defendant's plan was fully executed, or worse, intentionally sought to cause substantial harm or even death to one or more individuals. The fear instilled in Ariel Clary and her family upon discovering the fire outside can be readily heard on the multiple 911 calls pleading for the fire department to come as soon as possible to the house. In particular, during the more than 10-minute wait for the firefighters to reach the scene, Ariel Clary's mother, Alice, who had been sleeping when her son alerted her to the fire, can be heard becoming increasingly frantic, terrified that the flames from the vehicle were starting to reach the rear of another car, which was parked directly in front of a section of the house. And she strongly feared that the other car would explode and cause the house to catch fire. On the call, Alice Clary can be heard telling the 911 operator that her grandchildren, whose cries can be heard in the background of the 911 calls, were in the house and they were unsure if it was safe to remain in the house given the risk of fire. Crime scene photographs reflect that the heat and flames from the vehicle did in fact begin to melt the back of the sedan parked directly in front of the house, the damage getting dangerously close to the vicinity of the car's fuel tank. The danger that the house would catch fire if flames from the car's approach was especially acute here, given that fire investigators discovered accelerant had been placed around the perimeter of the home. The defendant also gave no regard to the safety of his 27-year-old stepson, who he recruited to engage in this serious crime with him. Though the defendant's sentencing submission attempts to emphasize Williams' dedication to his family and his role as a father figure to his stepchildren, Williams' decision to entangle his stepson in his dangerous criminal activity belies claims that he both acts as a proper role model and has the best interests of those around him in mind. Well, child, I'm going to venture to say that if the stepson, 27 years old, is old enough to know right from damn wrong, okay? So I'm going to venture to say that the stepson is a criminal him damn self, okay? Let me stop. The stepson, I'm sure we find out who he is, probably already have a criminal record and has now become a federal informant who flipped on his stepdaddy along with his aunt Cash Jones, okay? Or his cousin Cash Jones, who obviously set him up big time for this foolishness. So in addition, the search of the defendant's Google accounts revealed that on June 15, 2020, just 4 days after the date of the arson, he again searched the address of the residence, suggesting a possible intention of his returning to Ariel Clary's home. Disturbingly, a review of the defendant's Google accounts further revealed that on June 21st, 2020, after the defendant had already carried out the arson, the defendant searched for fertilizer and diesel fuel and subsequently visited websites titled, "How Do Fertilizer Bombs Work?" Detonation properties of mixtures of ammonium nitrite, base fertilizers and fuels, and why fertilizer can be an explosive mixture. Ooh. Next, standing alone, the defendant's act of setting fire to the vehicle was serious. However, the defendant's motive behind the arson, preventing or otherwise altering Ariel Clary's testimony through intimidation and retaliation in order to obstruct the government's case against Kelly, cannot and should not be ignored. The evidence of the defendant's intentions in committing this crime is apparent. As a preliminary matter, the defendant was clearly aware of not only the government's investigation and prosecution of Kelly, but of Ariel Clary's connection to the case as a potential witness. On or about December 20th, 2019, the defendant accompanied Cashmere Jones to a voluntary interview with federal agents related to the government's investigation of Kelly. In or about January 2020, Ariel Clary began cooperating with federal law enforcement. Several news outlets thereafter reported that Ariel Clary was cooperating with federal law enforcement. Ariel Clary also maintained a presence on social media when she publicly discussed how Kelly physically and mentally abused her. The government's investigation revealed that on May 23, 2020 and May 25, 2020, prior to the defendant committing the arson, the defendant visited several websites about female individuals who had made allegations against Kelly. He also searched surviving R. Kelly news and R. Kelly news. As noted above, the defendant had also done multiple searches specifically related to Jane Doe or Ariel Clary. Okay, child, let's take a break here and go back up and read some of these notes that they have here. Let's see, I know it was a couple I skipped. Okay, so note number 4 says photographs of the defendant's car from toll plazas on the route between Georgia and Florida late in the early morning of June 11, 2020 reflect that the defendant did in fact make the drive to and from Florida without a license plate. Significantly, a license plate reader in Georgia captured Williams' GMC Yukon in Hahira, Georgia, earlier in the evening in June 10, 2020 at approximately 7:25 p.m. with its rear license plate clearly visible, demonstrating that Williams removed the rear license plate before he traveled to Ariel Clary's house in an attempt to avoid detection by law enforcement. And then note number 5, the government's investigation also revealed that Cashmere Jones, who was also present when the defendant was arrested, had also previously warned Ariel Clary's parents to keep Ariel Clary from continuing to speak publicly about Kelly, stating among other things that it might be wise for you to protect your daughter from heartache she's going to endure through this and after. And y'all may want to think about that, because right now you got Ariel Clary out here looking crazy, honestly. So let's stick a pin here, because it says that Cash Jones was with her cousin when he was arrested, which goes back to my assertion that Cashmere Jones was the one that called police and told them where her cousin was at. I'm talking about her husband, where her cousin was located. Okay, so let's pick up here. Okay, so it says, moreover, the defendant's own conduct shortly after his crimes reveals his motive behind the arson. Tellingly, on June 28, 2020, after having committed the arson, the defendant conducted a search for witness intimidation and case law for tampering with the witness, and visited websites laying out the statutory language and penalties of Title 18 United States Code Sections 1512, witness tampering, and 1513, witness retaliation. Now, y'all know this boy ain't smart enough to be researching that kind of stuff. Come on now. And on July 9, 2020, the defendant visited websites that contained the statutory language for Title 18, United States Code Section 2423, Transportation of Minors, 2422, Coercion and Enticement, 2421A, Promotion of Facilitation of Prostitution, and
anywhere you said, anywhere.
that read 1. Tampering with a witness, victim, or informant. 18 United States Code 1512. The evidence is clear. Therefore, that was not a simple case of arson. The defendant used this dangerous and potentially deadly intimidation tactic in order to prevent Ariel Clary's cooperation from the government and testimony at trial. Okay. I need y'all, because this is so damn ridiculous. This is ridiculous. Put a 1 in the comments if you think Cash Jones set this boy up and planted all this information and did all these Google searches, because we know this boy is not smart enough to have been researching all this stuff. If he was just going down there to set that car on fire to intimidate Ariel, guess what? He would have jumped in the car and drove down there and set the car on fire. He wouldn't have been Googling all this other nonsense, looking up all this stuff. Cash Jones did this to her cousin. She did this to her cousin. You're not going to convince me otherwise. So put a 1 in the comments if you think Cash Jones did this to her cousin, and put a 2 in the comments if you think you think he was smart enough to have pulled this off on his own without her help and she did not set him up. So anyway, we're gonna go on down here to B. History and characteristics of the defendant and need for deterrence. Okay. It says Williams' criminal history also warrants a significant... Oh, Lord. Oh, I can't get my page right. I think I done clicked on something I ain't had no business clicking on. Let's see. Okay. Let's hit escape. Okay. All right, let's see. Okay, it took me way up that time. Where are we at? B. Okay, B. History and characteristics of the defendant and need for deterrence. Williams' criminal history also warrants a significant above-guideline sentence. His recent criminal activity was in no way aberrational, aberrational, A-B-E-R-R-A-T-I-O-N-A-L. So I guess they're trying to say it wasn't rational. He has a lengthy criminal history that dates back on his first arrest in 1998 as a minor, much of which is not reflected in his criminal history points. The defendant's criminal activities include, among other things, multiple convictions for burglary, grand theft, fraudulent use of identification documents, fraudulent use of a credit card, as well as additional arrests for other violations of the law. Moreover, the defendant violated his probation on multiple occasions, resulting in increased sentences. After each arrest, conviction, and term of imprisonment, the defendant had an opportunity to choose a law-abiding life. He did not do so. Indeed, even after being sentenced to lengthy terms of imprisonment, including terms of imprisonment of 5 years and 11 years, the defendant escalated to the serious criminal conduct for which he has been convicted. Not only was the defendant continually engaged in criminal activity generally, prior to committing the instant offense, he was no stranger to schemes using intimidatory tactics to threaten Kelly's victims. As noted above, Williams acted as a security guard during a previous scheme to intimidate Faith Rogers during the meeting at the Applebee's, where he was seen armed with a gun when Cash Jones threatened Faith Rogers with exposure of compromising photographs because of her participation in the SRK documentary. Significantly, even up until the moment of his arrest, the defendant was again brazenly violating the law by having in his hotel room a loaded firearm, notably with an obliterated serial number, after having been convicted of a felony, and as noted above, had even previously researched how to acquire a machine gun. Then they have a note there saying Kelly was in fact charged with the violation of Section 2421, not Section 2421A. So I guess Cash made a mistake there. Then it goes on to say, given the defendant's flagrant and consistent failure to follow the law, the defendant claims that he now looks forward to putting this past chapter of his life behind him and becoming an upstanding and contributing member of society rings hollow, and an above-guideline sentence is warranted in order to adequately deter the defendant from continued illegal conduct. In addition, a significant sentence is not only necessary to deter the defendant, but also all the would-be arsonists, as well as all those who would seek to intimidate or harm witnesses in order to obstruct investigations and court proceedings. Well, child, we know that prison sentences don't deter crime, because if they did, we wouldn't have all these damn people in prison, right? Okay, so anyway, C. Reflect the seriousness of the offense, promote respect for the law, and provide just punishment for the offense. The judicial system cannot function if individuals turn to obstructive tactics and serious crimes in order to pervert the course of justice, or if witnesses have to fear interference or retaliation if they come forward. As the court is aware, the Kelly case involved charges of particular sensitive nature. Victims, particularly those of crimes related to sexual assault, are often reluctant to come forward given the trauma and stigma associated with publicly discussing their experiences. Here, Ariel Clary's trauma was compounded by the frightening experience of having someone come to her home in the middle of the night and set fire to a car in her driveway, as well as the fear that others could try to similarly retaliate against her. If victims and witnesses are concerned that this type of conduct would not be adequately punished, it could chill victims from outcrying and stall investigations due to a lack of cooperation with witnesses. The negative effect on the criminal justice system cannot be overstated, and this type of conduct cannot be tolerated under the law. A significant sentence above the applicable guidelines range, or range which does not account for this aspect of the defendant's conduct, nor does it account for the fact that he refused to cop to the scheme that y'all had set him up for, therefore is necessary in order to clearly reflect the seriousness of the offense, promote respect for the law, and to provide just punishment for people who we think we can set up and trap, who refuse to go along with our plot. Okay, y'all. Y'all know it didn't say all that right. Let me read what these folks wrote in this thing. It said, a significant sentence above the applicable guidelines range, a range which does not account for this aspect of the defendant's conduct, therefore is necessary in order to clearly reflect the seriousness of the offense, promote respect for the law, and to provide just punishment. D. Protection of the public from further crimes of the defendant. Now, we do need protection from him, okay? We need protection. Because I think that man was at his house minding his damn business when Cash Jones rolled up on him and came up with this foolishness and got him involved. That man probably, they said what? He was sentenced in 2004, 2006, and then ended up serving 11 years, which would have put him around 2017. So that man probably was living a law-abiding life from 2017 and 2018. And then Cash Jones rolled up on him. He probably couldn't find no job because he had a criminal record. He needed money. She probably offered him some money. Then he went to New York with her and, you know, had the little meeting with Faith and her mama Kelly. Then she done got him down here in Florida, setting rental cars on fire because her and Angelo done fell out, and you know their relationship done went astray. Alice probably found out about the relationship and all that nonsense, and now she done got this boy sentenced to 96 months in prison. See how now that's what family will do for you. You know, he probably was minding his own business. He got a stepson, so he obviously got a wife. He probably done got married since he got out of jail and everything, was trying to do the right thing, and then here come Cash with the foolishness, and they got this boy locked up. How many years is that, y'all? How many years is that? Is that 8 years? 8 times 12? 6, 1, 9? Yeah, she done got this boy 8 years in prison here. So anyway, here go, what else they say? Finally, a significant above guideline sentence is necessary in order to protect the public from the defendant. As discussed above, the defendant's conduct of conviction reflected a complete disregard for the safety of others and a likely intent to cause substantial harm or injury to Ariel Clary specifically. But once again, we think it was really Angelo Clary was his intended target. Or y'all told Cash Jones to go and set this whole thing up to try and get Mr. Kelly into more trouble, and was probably the reason the boy didn't cop a plea for y'all was because didn't get in there and say that he did this on behalf of R. Kelly, because he might not have been smarter than the fifth grade, but he did no retaliation, and he knew that Cash had done set him up, and he wasn't going to let her have the victory in that. Okay, so I mean, he done spent 11 years in jail. He figured, what the hell else? Okay, what's a few more years in jail? I ain't got to work. You know, I got a place to, what they call it, 3 hots and a cot. Okay, so he probably was just like, okay, I got your number. I'm not going to go in there and say that this man hired me to do this, or I did this on behalf of this man. I'm going to say I did it on my own. Okay. And so now y'all mad and want this man to get all this time in prison. And all he did was set a car on fire. Anyway. In seeking to intimidate Ariel, Clary, or worse, in order to prevent her from testifying against Kelly, the defendant not only violated the law, but also arrogantly and dangerously sought to take the law into his own hands to obstruct the government's investigation. Moreover, the defendant's troubling research for information on machine guns and materials to make bombs demonstrates that the defendant poses a risk to the victims and other witnesses who testified against Kelly, as well as the public generally. And then before we read the conclusion, we're going to go back up here and read note number 7, which says, during a post-arrest interview, after waiving his Miranda rights, Williams stated that while the gun found in the hotel room was not his, he may have moved it so his fingerprints may be on the gun. Williams further stated that in the previous year he had borrowed the gun in order to confront an individual who he claimed had been following Cash Jones. Now, who do we think that individual was? Angelo Clary. All right. Okay. So, conclusion. For the foregoing reasons, the court should sentence the defendant to a significant above guidelines range of imprisonment. Respectfully submitted, Breon Peace, United States Attorney. Okay, so before I end this video, let me go, because I had to come outside because somebody was working in my house, but I'm going to go back in here so I can get some internet connection and see what the other attached documents were. So guys, just hold on for a second. Okay, the first 2 exhibits were pictures of the car that was actually set on fire, and then the car that they said was in front of that car. And then exhibit 3 was a character witness from someone named LaToya Jefferson. And it says, to whom this may concern, this letter serves as a character reference for Michael Williams, who is a dear friend and like family. Michael is a very warm, caring man who is very respectful and family-oriented. He is also very helpful and often assists when anything mechanical or technical needs repair. My youngest son brought his first car, and without having to ask him, he had offered my son to teach him how to maintain his own vehicle. I've also witnessed the time and love that he shares with his mother. He never left her side when her mom, his grandmother, was transitioning. He was there with her when she took her last breath. To me, that takes a very strong individual, and it was very admirable. He exhibited strength and compassion. His compassion extends to giving awesome advice as well. Very practical advice. He is a very honorable and fair man. He cares for his family, wife, and children. Have witnessed him take a shell of a house and turn it into a warm home full of love for his family. He is resourceful, calm, peaceful, kind, and patient. Well, when Cash approached him, he should have told her to go somewhere and sit down. And we wouldn't be here right now. Okay? So let's see what else we got here. Okay, here is another character witness. It says, the character of Michael Anthony Williams. Michael Anthony Williams is a person that I have known all his life. I was there when he was born at the Miami-Jackson Memorial Hospital, March 11, 1983. A proud father I was, and so was his grandparents. He is a good, humble man that tries to assist anyone if he can, using what he was taught or experienced. Michael always seeks attention from his family and friends, but acknowledged that he's not where he would like to be in life. His uncles, which were his mentors, are mostly deceased, and he clings to his mother for all other support. Whatever you ask him to do, he will try to do his best. As a young child, Michael's father left to be a part of the armed forces, which caused a separation between him and his father. During his teen years, Michael found himself in trouble at school and with the law. Michael was trying to please everyone in his family and friends by doing what they wanted or getting things for them. He was still a child that needs to be coached and mentored, but he got exploited by those in Miami, guided him to do unlawful things. At the age of 14, Michael was able to live with his father at Hunter Army Airfield, Georgia. His father took him to a psychologist, assist him with feeling of neglect and his need to please everyone that he called family and friends. Michael's behavior improved while he was seeing the psychologist and doing well in school. However, his father was called to be deployed, so Michael had to return to Miami with his mother. Michael's undisciplined behavior got worse due to not having anyone to assist him with his issues. Michael believed that what he was doing was helping his family and friends in Miami, and they needed him. Michael had TRICARE standard medical insurance to assist with his asthma illness. Michael stated that he had to steal medicine from the stores to help himself with his asthma illness. When I asked why did he have to steal, Michael responded that no one cared to help him, but he always helped them. His father was always away, but communicated by mail. That was not enough to keep him out of trouble. Michael needed parents that would be there for him, to guide and mentor him in a direction that would have made him a lawful participant in society. Even now, Michael is still trying to gain friends and acknowledgement from others by doing what they ask. Now, that was a low-key dig at Cash Jones. I am his father, and it pains me to see my son grow up believing that he was alone and those around him seemed to not care enough. Go give him the attention that he needed as a young teen, now man. Although his negative experiences and issues doesn't excuse him from his negative behavior, it explains why he still seeks attention from family and friends by doing what they ask of him. I believe that Michael still needs help understanding that he does not have to seek acknowledgement from anyone to love himself. The things he did is without a doubt in my mind that he is helping someone the way he was taught and experienced. Rudolph A. Williams, U.S. Army retired, father of Michael Anthony Williams. Now, this man all but just said that Michael did this because Cash Jones asked him to. Okay? Now, that's how I understood it. How did y'all understand it? Okay, all these attachments seem to be counter references, letters to Judge Donnelly. This is the last one I'm going to read. It says, Dear Judge Ann Donnelly, my name is Latasha McCoy, and I am Michael Williams is my soon-to-be brother-in-law. I am expecting twin boys in May, and I would love for him to be here for his nephew's arrivals. Michael is a good-hearted person. He tries to help everyone and anyone out that he can. Michael tries to lend a helping hand to family and friends. When you call Michael, he is there day and night. Michael is a caretaker of family and friends that are in need. Michael's family really needs him right now, especially with the COVID going on. He should not be in prison. Sincerely, Latasha McCowan. Okay, this one is from someone named Latrice Kemp. And it says, to whom it may concern, my name is Latrice Kemp. I am currently employed for the Miami-Dade Public Schools, acting as senior manager in a cafeteria. I have had the pleasure of knowing Michael Williams for 20 plus years. He has been a very close family friend and a positive role model for my sons who currently like male influencing. I can recall one year a hurricane came and knocked my door off track, and Mr. Williams came to help replace the frame and even replace the door for me and my family. Mr. Michael Williams has never showed any disrespect or dishonesty. He has always been dependable, trustworthy, and just helpful. As a single parent, he was one of the many people who I called the village to help with my tribe. I ask that you consider his character in his sentencing. While this year has hit hard for a lot of us due to the pandemic, I can honestly say it hit me even harder to know that Mr. Williams was incarcerated. I have always known him to be an outstanding member of the community and nothing more. In closing, I ask that you please consider this letter in his current sentencing. Warm regards, Latrice Kemp. Okay, there's another document here, but it's like 15 pages long, and I don't feel like reading all this, but it basically is from the probation office where they're basically explaining their recommendation of the 60 to 63 months that they recommended. They say factors are the nature and circumstances of the offense and the history and characteristics of the defendant. 2, the need for the sentence imposed to A, reflect the seriousness of the offense. And I think I read some of this to you guys. In respect for the law and to provide just punishment for the offense. B, to afford adequate deterrence to criminal conduct. C, to protect the public from further crimes of the defendant. And D, to provide the defendant with needed educational or vocational training, medical care, or other correctional treatment to the most effective manner. The kinds of sentences available, the kinds of sentence and the sentencing range, the need to provide restitution for any victims of the offense. And so it goes on and talk about his personal history and character. Let's see. As an adult, Mr. Williams moved from southern Florida to Atlanta, Georgia, where he met his present wife, Yuki Blake. Miss Blake has 2 children from a prior relationship, Patrick Blake and Mary Blake. Mr. Williams married Miss Blake in 2014. Following his marriage to Miss Blake and prior to his arrest, Mr. Williams assisted the entire family, including his 2 stepchildren, financially as well as emotionally. However, Mr. Williams' financial support did not make the family immune from hardship, and during many periods his family struggled both financially and experienced several setbacks, including suffering detriments to their collective and individual health and well-being. One of the most notable hardships to befall Mr. Williams and his family occurred in 2016. In September of 2016, Ms. Blake was involved in a serious automobile accident in which her right leg was severely injured. Ms. Blake had to be cut out of the vehicle at the scene of the accident due to the physical trauma caused by the accident. She's now unable to bend her foot, or in order to walk, she must use a walker or otherwise limp. Due to Ms. Blake's disability following the 2016 automobile accident, Mr. Williams has had to assume almost complete responsibility for assisting and supporting the family financially and has been the family's primary caretaker. And then they go on to talk about they don't have children together, but he has 1 biological child with a lady named Kiana Reese, with whom he had an on-again, off-again romantic relationship. Tragically, Mr. Williams' biological child with Miss Reese did not survive infancy. While Miss Reese gave birth to a beautiful baby boy, Mr. Williams' son, their baby sadly died just 1 hour after birth. Let's see, family status, environment. They just basically talk about he was close to the mother. And the letters, so they're explaining, just giving bio to those letters that I just read you guys. Let's see. physical and mental health condition. Mr. Williams has suffered from several different chronic health conditions throughout his life. Mr. Williams has suffered with chronic asthma since childhood and has to use an albuterol pump due to the severity of his asthma. In 2008, Mr. Williams suffered a lung collapse and had to be hospitalized for 1 week. He was in a serious motor vehicle accident in 2003. Mr. Williams' incarceration has been detrimental to his physical health. During his incarceration, Mr. Williams contracted COVID-19 twice. Remember, we talked about that when they kept delaying his plea hearing. I said he must have COVID. And so I'm sure that was complicated by the asthma. And then we know that he's dealing with depression. I think we talked about that in another video. Employment and financial struggle. We know he probably can't find a job because of his criminal history. But they say he worked briefly at one stop in Miami, but had to terminate his employment due to transportation issues. Between 2014 and 2016, he worked at Southeast Connections, but ceased his employment there due to unreasonably long hours and the aggravation of his asthma. So when did he serve these 11 years in prison? Or did he get out of prison in 2006? Maybe I misunderstood that. And then they says from February 2020 to August 2020, he worked as a Lyft driver and earned approximately $500 a week. In March of 2020, he established a construction company named Emperor Remodeling, in which he invested approximately $15,000. However, he has made no profits from such company since he was incarcerated in August of 2020 and is no longer able to rely on the company as his means of earning. Mr. Williams also purchased 40 acres of land in Nevada for $30,000 as an investment property, but likely has forfeited ownership of that land because he missed 3 monthly payments. So where he done got $45,000 from, y'all? This is interesting. As of now, Mr. Williams' wife is currently in college studying culinary arts while employed as a cook at the Holiday Inn. So maybe she got money from the car accident that she was in that injured her foot. And that's where they got that money from. Let's see. The nature and circumstances of the offense. Mr. Williams has admitted his misconduct and he deeply regrets damaging and destroying by means of fire a vehicle used in interstate and foreign commerce. Mr. Williams made mistakes, feels remorse for his actions, and is eager to close this chapter of his life. From the onset of his arrest, Mr. Williams has attempted to take responsibility for his actions. Remaining factors: the need for the sentencing imposed to reflect the seriousness of the offense. A sentencing judge has wide latitude to decide the proper degree of punishment. We know that district courts must further consider the types of sentences available, and we already read that part in the prosecution's letter demanding that he get a longer sentence. It says a fair and just sentence is not a rote mathematical exercise. Rather, it must involve judgment on the behalf of the sentencing judge. And they're reading from different lawsuits where they're basically saying that despite what they recommend, the judge still has latitude to give a stiffer sentence. And it says, as the court reflects upon Mr. Williams as an individual in deciding the sentence in the instance case, I respectfully urge Your Honor to consider the information offered in this memo and determine that a sentence of 60 months is just and proper. It is hereby submitted that a sentence of 60 months, along with any conditions deemed by the court to be appropriate, will reflect the seriousness of the offense. The record makes clear that Mr. Williams deeply regrets his actions and accepts responsibility for the same. Mr. Williams has also spent months in custody and has chronic asthma, puts him at a higher risk of developing complications due to COVID-19, which he has already contracted twice. Moreover, Mr. Williams has proven his value to society irrespective of his serious mistakes and personal shortcomings. He is admired by those who have known him and has served as a pillar of support for numerous family members and friends. Mr. Williams' family members feel his absence keenly. His stepdaughter's mental health is suffering severely due to his incarceration, and his wife reported that she too feels lost without him. Moreover, Mr. Williams' entire immediate family is struggling financially without income from Mr. Williams, which surely has contributed to Mr. Williams' intensified feeling of depression and anxiety. Further, the testimonials included in this memorandum and otherwise submitted to the court demonstrate that the requested sentence will provide respect for the law and provide a just punishment in Mr. Williams' case. Conclusion. On behalf of Mr. Williams and his family, I thank Your Honor for considering this memorandum. We look forward to addressing the court on November 17th. Okay, so I thought this was from the probation office, but he shared what the probation office said and then put his part in there. So this is actually from his attorney, which is Todd A. Spodek out of New York. So, this is a mess. Anyway, Michael Williams was sentenced today to 96 months in prison, which, if my calculations are correct, is 8 years, but y'all correct me if I am wrong, because it wouldn't be the first time. I don't have my well, actually, I do have a calculator here. Let's calculate this. 96 divided by 12. Yeah, 8 years. So he was sentenced to 8 years in prison. So that's it for me. This has gone on long enough. Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.